Hey everyone, welcome to today's explainer. If you're gearing up for the NPPE, you already know that some of these questions, well, they kind of feel like they were designed just to trip you up, right? So today, we're taking a masterclass approach to deconstruct a really tough question all about professional liability. We aren't just going to memorize an answer here. We're going to completely break down the logic, the actual law, and the exact skills those exam designers are testing so you can walk into test day with absolute confidence. Let's get into it.
Okay, here's our quick roadmap for today. We'll start with the NPPE challenge question itself. Then we'll move into identifying the core concept, legal theory, and liability, dissecting the answers, a key terminology review, and we'll wrap it all up with a final edutational takeaway.
All right, Section 1, the NPP challenge question.
Let's look right at the prompt. It reads, a professional includes an aggressive disclaimer that attempts to exclude liability for negligence entirely. What limits enforceability? Put yourself in the exam room for a second. The clock is ticking down and this pops up on your screen. Keep in mind, the wording they use here is super deliberate.
And here are your 4 options on the board. Option A is insurance policy exclusions. Option B, public policy and statutory prohibitions against excluding liability for negligence causing foreseeable harm. Option C is client sophistication. And option D, the disclaimer purports to exclude liability for all types of damages without any exceptions. Take a quick second to look these over. Actually, go ahead and lock in your guess right now before we break it down. You got it? Awesome. Let's move forward.
Moving right along to Section 2, identifying the core concept.
To beat the NPPE, you really have to know exactly what part of the syllabus they're targeting. In plain terms, this question falls squarely under the umbrella of engineering law and civil liability. Whenever you see words like liability, negligence, or enforceability, your brain should instantly switch into legal mode. We're not just talking about professional ethics or simple conflicts of interest here. We're talking about the hard legal boundaries of how a professional practices and forms contracts.
Notice this specific phrase from the prompt. Aggressive disclaimer that attempts to exclude liability for negligence entirely. What the question designer is really measuring here is your ability to recognize the hard limits placed on contractual freedom. As professionals, we use contracts every single day. But the exam wants to know, do you understand that you can't just draft up a piece of paper that gives you a free pass to be reckless? They are testing your knowledge of fundamental professional duties versus private contracts.
Okay, Section 3, legal theory and liability. So the core theoretical concept you absolutely must memorize is this. While professionals can certainly limit some liabilities in a contract, maybe capping financial damages for certain types of delays or really specific errors, societal rules and statutes strictly forbid using a contract to completely escape responsibility for gross negligence that actually harms someone. Basically, you cannot contract out of your fundamental duty of care. Society grants you a license to practice engineering or geoscience based on the trust that you're going to protect public safety. A private contract simply cannot override that public trust. No way.
Let's get into the fun part. Section 4, dissecting the answers.
If you guessed option B, huge congratulations. The correct answer is B. And this just brilliantly illustrates our core theory. The ultimate limit on a contract's enforceability isn't actually what the client agrees to, it's what the law allows. The law actively steps in through public policy and statutory prohibitions to basically void any disclaimers that try to erase a professional's liability for causing foreseeable harm. In the eyes of the court, a clause that essentially says, "I'm not responsible if my careless engineering hurts someone," is fundamentally invalid because it violates the public good.
It's easy to see why those other options are so tempting, but let's break down exactly why they're wrong. The examiners are intentionally using common misconceptions here. Look at option A, insurance exclusions. That's a total trap. It confuses private insurance limits with overriding legal enforceability. Your insurance might not cover a specific claim, for sure, but that doesn't mean the law somehow enforces your disclaimer. Option C is another classic trap, client sophistication. Some folks think, well, if the client is this massive, super smart corporation, they can just sign away their rights. Incorrect. A smart client cannot legally waive basic statutory negligence protections that are meant to protect society. And finally, option D focuses just on the breadth of damages, saying all types without exceptions. That is a classic distractor. The real issue isn't the types of damages being excluded, but the fundamental legal prohibition against excluding negligence that causes foreseeable harm. Don't fall for the distractors, guys. Always trace it back to the governing law.
All right, Section 5, key terminology review.
First up, we have the aggressive disclaimer. As it's used in the question prompt,
This refers to a contract clause attempting the pretty extreme action of excluding liability entirely. It's not your standard limitation of liability clause, it's a blanket attempt to say, I am not responsible for anything, ever. And as you can guess, the law generally frowns heavily upon these.
Next up is negligence causing foreseeable harm. This is a massive concept in civil liability. It essentially refers to a professional failing in their standard duty of care, which directly results in damage or injury that a reasonable professional could have easily predicted. Think about it. If you design a bridge using materials you explicitly know are subpar, its collapse is foreseeable harm. You can't just slap a disclaimer on a blueprint to excuse that.
Finally, public policy and statutory prohibitions. These are the actual legal mechanisms that act as a shield for the general public. They're overriding societal laws, rules, and precedents that empower a judge to look at a signed contract and say, nope, we are striking this clause down because it violates the basic standards of safety and professional accountability that our society demands.
And finally, Section 6, our final educational takeaway.
So if you remember nothing else, the absolutely crucial point to take away from this entire lesson is our golden rule. Statutory laws and public policy will always trump a professional's attempt to completely contract out of negligence. Whenever you're faced with an NPPE question pitting a private contract against overarching public safety or established statutory law, the law and public safety will win every single time. Memorize that hierarchy, and you're going to navigate these civil liability questions with total ease.
As we close things out today, I want to leave you with this thought to mull over. As you continue your exam prep and eventually earn that hard-won license, ask yourself, how will you personally navigate the boundary between protecting your business with smart, reasonable contracts and upholding your overriding ethical duty to public safety? It's a tricky balance that every true professional has to strike. Keep studying hard, trust your knowledge of the law, and I'll see you in the next explainer.